third in a series to get all of those unusual credits. And we're so pleased to have the opportunity to sponsor this incredible program and this really valuable resource that the CCCVA is providing to the community. At ADR Services, Inc., we are so pleased that we're starting to go back to the office, though we recognize many folks are still working remotely. We do offer hybrid hearings, in-person hearings, and Zoom hearings. And we are really looking forward to having this presentation available today and hearing what the speakers have to say on this concept of civility in what is starting to feel like a more and more uncivil world. So without any further ado, I'll turn it over to Mark LeHocky to introduce our other speakers.
Well, thank you, Katie. And just before you go, I have worked in all of the ADR Services office throughout California. I don't recognize that office behind. So did you open a new office during COVID that I'm not aware of?
Yes, it's called My Apartment, and I have been spending a lot of time here in this one, I must admit.
It's very nice. Well, thank you, and thank you, everyone. I really, really appreciate everybody participating today. Obviously, all the people who dialed in, but Ann and Katie and ADR Services, the Contra Costa Bar Association for helping to put this together. I'm also very lucky to join this program with Bette Epstein, Honorable, Paul Beeman, Audrey Gee, and I will introduce them in just one moment. But I just want to share an observation. The idea for this program, we'll dive into in a second, about how to address competency issues was something we've been noodling around for months. And you'll hopefully get some value out of it as we share some perspective about what we can do differently. But I am awestruck by what's happened in the last few months, particularly as it relates to mental health issues and especially the conversation. If you're a sports fan like I am, you've read the newspaper about Simone Biles pulling out of the Olympics, and apparently attributable in part to some mental health struggles, not just physical struggles. And a few months ago, one of the world's best tennis players, Naomi Osaka, pulled out of the Roland Garros, the French Open, also citing in part those issues. It's just a fascinating time to be talking about this particular matter. So let me roll forward. Bear with me as I have terrible skills here in terms of putting all this stuff up there. But if I've done this right, let's see. Have I done it right, Katie? I see my screen, but I don't see the group. Here we go. All right. Yep. Here's the promise for everybody. I am not a fan of PowerPoint, but we need to go through some material. We will do the slides fairly quickly, and our goal is to have an open-ended conversation with our panelists. So bear with us for a few minutes while we go through these things. So what are we here? Let's see, find my. I have to move everything around, folks. Give me a minute. Too many things on my screen. I just realized, there we go. So our plan of attack here for today, again, as I mentioned quickly, the objectives of our program we'll get to in detail in a minute. And before we dive too far into that, we want to talk about our panel because they all bring unique background and perspective, very appropriate for a conversation. And then we do mean to have this take place as an interactive program. So if you have questions, thoughts, please pass them along. I think you can use the chat function in doing that. We'll make a real-time decision about addressing them in real time. We might save some for later, and hopefully we'll also save time for the end of the program time to take a deeper dive on any of these things we're going to talk about. So with that, I want to introduce our panel. And I'm going to start alphabetically. It's not because you're a judge, Judge Beeman, but alphabetically, you go first. With Judge Paul Beeman, who was on the bench for all of 18 years in Solano County Superior Court, including serving as the presiding judge. He was also the chairman of the court's Alternative Dispute Resolution Program for 12 years. And before that, Judge Beeman spent over 26 years as a trial lawyer in private practice, where he tried more than 30 civil jury trials and has mediated or arbitrated another 150 matters. So welcome, Judge Beeman.
Thank you.
In addition, we have Bette Epstein, who brings a different background, which is very appropriate for our conversation, because in terms of her current practice, Bette is spending her time mediating trust and estate matters, trust and dispute matters, which she's been doing since 2000. But that is following a remarkable career, first as a licensed psychotherapist, and then as a litigator for over 30 years, when she has turned her efforts towards ADR work. And during her legal career, both as a mediator and before that as a litigator, she has been highly regarded as one of the Bay Area's leading probate specialists, and has spent 28 years of litigation career handling a full array of estate and trust matters. And we're very, very lucky to have her. Welcome, Bette.
Thank you.
Now, I'm going to introduce Audrey Gee, and I'm going to warn all of you, if I read her whole list of accomplishments, our whole 90 minutes would be absorbed. But I will tell you, as having read that whole 90 list, I feel like a slacker by comparison. Audrey Gee, as many of you know, is actually the founding partner of Brown, Gee & Wenger, a business law firm in Walnut Creek, California. And she has over 25 years of litigation experience representing companies large and small, including multi-billion-dollar companies, a full range of industries in employment, individual matters, class action matters, proceedings before the California Department of Fair Employment and Housing, and corporate litigation work representing, again, multi-billion-dollar companies in contract disputes, complex real estate matters, and many, many more. She was awarded the inaugural Outstanding Women Lawyer Award by the Contra Costa Women's Section, and she has been selected both a super lawyer and is previously recognized as a rising star when she was under 40. I thought, Audrey, you were still under 40, but we'll keep that a secret. That's not all, folks. Audrey was past president of the Contra Costa Bar Association. She served on the Bar Association's board of the employment law and the women's section, and has served as the chair of the Judicial Nominations Committee as well for Contra Costa. Audrey, welcome as well.
Happy to be here.
So my story is much shorter and far less interesting. I was a litigator for roughly 20 years, then became a general counsel for some companies where I got to litigate and manage everything under the sun except estate planning and trust matters. Thank God there was something I didn't have to touch. I also am on the faculty at UC Berkeley's law school and their business school, which constantly reminds me of the Groucho Marx line that about I would never join a club that would have me as a member. So if you contribute to those schools, you may want to stop at this point. But on the serious side, I've also been mediating now 22 years, starting as a volunteer at the federal court in San Francisco, and switched over to this work full-time about 10 years ago. And I will share how at least some of those experiences, especially the opportunity to do both mediation work and doing general counsel work at the same time, gave me a lot of opportunity to experiment with how you manage disputes, how you manage executive teams, and getting ready for disputes and being prepared, things that hopefully will be perceived, as we're talking about today, as things that reduce stress and anxiety. So let's go for just a minute more about, again, what our objectives are. You've all, I assume, our attendees have participated in one or more competency programs, and that are all typically great quality programs that address the issues of identifying substance abuse problems, treatment for those problems, and the like. And we're going to address a portion of that. But we're going to do it in the context of what are we dealing with, both what are lawyers dealing with today, what are our clients dealing with, so-called problematic behavior, which sometimes is an indicator of mental health issues and the like. And then most importantly, we're going to talk about what can we do as practicing lawyers to help reduce and manage that bad behavior? How do we get in front of it? By preparing clients and managing expectations. How do we deal with adverse interests in court negotiation and ADR settings? And what are some strategies we can share in terms of helping our clients and in turn ourselves reduce stress and improve outcomes? That's our game plan for today. Now, when we're putting this together, the other thing I want to give Bette in particular credit for, the original conversation was how do we deal with competency issues as they manifest, unfortunately, in a negative way in the context of court matters, ADR efforts. And Bette, you made the point much better than I. This is not just about ADR. It's not just about court matters.
Yeah, I think it's really important to remember our colleagues that handle transactional matters, because for them, they may have a client whose business success is on the line with the importance of a lease negotiation or a merger and acquisition. And so we want to remember those colleagues who certainly deal with very stressful circumstances.
So again, the promise to all of you is we will go through some slides fairly quickly and then turn off the darn slides and have a conversation about strategies. But we need to provide context for it. So excuse me, we've done that. So to kick things off, Judge Beeman, you came up with a very appropriate quote. Would you care to share with the group and why you put it before us?
Well, I'll read it. It has always seemed strange to me the things we admire in men: kindness and generosity, openness, honesty, understanding, and feeling are the concomitants of failure in our system. And those traits we detest, sharpness, greed, acquisitiveness, meanness, egotism, and self-interest, are the traits of success. And while men admire the quality of the first, they love the produce of the second. Essentially, you can I'm sure everybody in the audience understands it. It's that you're fighting two battles at one time, and you're trying to achieve a balance. And balance is very important. Your physical conditioning, your mental conditioning. I mean, all of you have a life other than the law, hopefully. And that's what you're balancing. And it's not hard to get it out of whack. You could sit down when this program's over and do it while we're talking. You can make a list of at least 3 and probably 5 dozen different problems that you have to worry about. And whether they're in the forefront of your mind or not, they're in your subconscious, and you are constantly looking at all the different issues that exist. And why is that important? Well, it's important for your peace of mind, for your family's peace of mind, for your life. You only get one bite at this apple. And if you wind up spending 5 years in a bottle, or over medicating yourself and risking all types of criminal and professional penalties, well, that's not good for you. You never wanted that for yourself. You mentioned a couple of the Olympic athletes that are having some issues. Don't forget about Tom Girardi. I mean, he used to be the leader of the legal profession in America. And look what's happened to him. I mean, how many nicks and divots did they take on his mental health throughout the 50 or 60 years he's been practicing law? Take assessment of yourself, okay? I'll stop there for the moment. One thing I want to talk about, and Mark, if this is inappropriate, just holler. We do have this rule, and it's the rule, the first rule of the professional rules of conduct here in California. It deals with competence. And so Mark decided it'd be a great idea if I touch on it. So I'm going to do a little bit more than that. The new rule came into effect in March of this year. It added gross negligence as something you're not supposed to do. You might say, why did they do that? I'm not completely sure. They say they did it to strengthen consumer protection. And along those same lines, they took diligence out of this rule and gave it its own rule. So now you have a separate rule to be diligent. They think that that gives some type of respect to the law business, to underscore the importance of diligence for, so that the consumer benefits. We could talk about that a lot, but I think there's other things we want to get into. They gave you the option now as an attorney, if you get into a case and you find out or you feel that you're over your head in the matter, that you could refer it out. That wasn't, you always had the ability to refer it out, but now they put it in the rule that if you're, not doing the best job, you're falling short, you need some help, you can refer it out. And so I guess it's important that they noted that and tried to perhaps encourage people to do it when they are in trouble. They also, when they modified this rule, they used it as a opportunity to add 3 new rules. And these are rules 5.1, 2, and 3. And those deals with your duties and responsibilities of competency insofar as supervising others and supervising yourself to, within the confines of a large firm. You also look at the comments on this rule 1. This one's a little unnerving to me, but you, in addition to keeping abreast of the law, which everybody tries to do, you're also now shouldered with the responsibility of understanding all of the benefits and risks associated with relevant technology. Just something to be aware of, but that's it for the official rule. I don't want to go on and dwell on that extensively, Mark, unless you want me to say something additional.
Well, I think we'll circle back to it, Judge Beeman, and I appreciate it. And I believe the handout materials that will come to all the attendees, if you didn't get them with your login, you will get them following, include not only copies of the slides, but include sections that address mental health resources, articles, writing. We'll touch on some of the high points in a second. But to Judge Beeman's point, there are a lot of rules embedded that apply to issues such as competence and its sister of sorts, civility. Great question is why do we have to continue to add new rules to address that? I have a slightly different question for Audrey and Bette, and is keying off the John Steinbeck quote, I'm sure written about 1930s, 1940s. But the observation that certain types of traits, the sharpness, the greed, the sort of the toughness, why are those perceived to be things that clients want? I'm curious if you have thoughts about why people expect that from us, as opposed to operating the way I think all of us on this call are participating. Any thoughts, Audrey?
Yeah, I think popular media really shapes a big consciousness or expectation of how lawyers are supposed to behave. And it might, good TV is not necessarily good lawyering. And sometimes when the junior attorneys come up and you don't have role models because you haven't seen people ahead of you in terms of how do you work through a case, what are your role models? The role models is the popular media, right? Where people are beating up on each other and, they're trying to take pot shots and personal attacks, and where it's really it's like a cage fight, right? And the more of a cage fighter that you are, the better the attorney that you're perceived to be, at least in a TV show, right? And in how many snarky remarks you can make. In real life court, like the snarky remarks, we're trying to not do that, but people don't have those role models, right? And so I think part of it is that taking the time to mentor and taking the time, especially if you're in a larger firm, to bring your junior attorneys with you, and you can figure out on how to write off that time or whatnot, but making those opportunities for learning would be really good.
That's a great point. And just as an aside, I couldn't agree more about the value of mentoring. And for those of you that do come to mediations and the like, please bring junior lawyers along. Figure out how, if your client won't pay for it, figure out a way to still make sense of it. It's great for them, and frankly, it's fun for us too in the mutual chair. Betty, other thoughts before?
My thoughts exactly in terms of the expectation that people, unsophisticated, inexperienced clients have about what good lawyering looks like. You know, we hear about, you know, I want a barracuda to represent me, thinking that a barracuda is someone that raises their voice and pounds on the desk and does things that most of us wouldn't think to do. And so it's educating our clients to help them appreciate what good lawyering really looks like, including having good relationships with opposing counsel, which oftentimes clients don't understand that it's in their interest to not have to document every conversation, every telephone call with opposing counsel because you don't trust them. And so I do think that part of what we can do, in addition to the mentoring, which certainly is a critical role that we can serve, is educating our clients as to what good lawyering should look like.
Absolutely.
And we've just scratched the surface on some of these points, but I'm going to take us all through the slides to get rid of this darn slideshow part of it. Because again, I think part of this great conversation, we want to wrap around the fact of why we have the conversation, which has to do with what is happening out there, not just to lawyers, but we'll focus a lot on lawyers. So we're going to come back in much more detail to what can we do differently. This is a great start, but bear with me for a minute. Since I have to go through this slideshow, why is it not moving? There we go. Ah, there we go. Did I mention I have limited skills? All right. So context, why the conversation? Is it just something going on that lawyers are engaging in bad behavior? I think, and much more smarter people think there's much more going on in the background. So to just quickly summarize, and again, this is encapsulation of what's in materials that are referenced and tons of links for great data, but it's showing a disturbing trend in terms of the increasing prevalence of mental health issues. Now, we already knew, I'm sure anybody who's been practicing for a number of years, we're not a good group in terms of comparing against other parts of the population. Lawyers already have higher incidence of alcohol issues, depression, anxiety. But folks, it's getting worse from jumping from 2016 to 2020. You can see the data here that shows a prevalence. I mean, that folks, 64% of people reporting a study in 2020, conducted pre-COVID, by the way, of 3,800 lawyers showed 64% reported having some form of anxiety. Maybe not all severe, but anybody reporting anxiety, it's a thing. And then again, over 30% reporting symptoms of depression, 10% reporting having alcohol problems. And again, that's pre-COVID. So from that, we go to COVID's made matters worse for lawyers and clients. Audrey, Betty, would you care to address the data here?
Yeah, you know, I mean, it's astonishing, right? And when I was reading the statistics in terms of the anxiety and the depression, and if you flip to the next slide, it really talks about like that thinly eroding line between, between work and home. And it talks about, so it's a great article. It's in the American Lawyer. I recommend that you read it. And you know, it's when we're like all shut down in the pandemic. I was working at home, and I still am kind of like hybrid, like both at my office and then also at home. And then at home, I'm on my dining room table. And I was talking with another professional woman, and she was saying, I'm at my dining room table. And so every time I walk by to the kitchen or whatnot, I see my work just sitting there looking at me saying, please work on me. And I found myself saying, I'm doing the same thing. And so you find yourself working at all hours, all the time. It worked for me because I like to work late, but for some other people, especially the early birds who woke up really early, and then they have, because clients are doing the same thing. They're working at their dining room tables. They're working at all of these long hours. So it's before pandemic, most people respected probably, they wouldn't call you past 6:30. Now, regularly, I'm getting calls from clients 8 o'clock, 10 o'clock, email, lots of emails at midnight, 1 o'clock in the morning, and we're having dialogues, right? So it's not just, oh, you'll answer it in the morning, but I think it's very stressful for some attorneys who aren't able to, that's not their work style, or that they're not able to set barriers with their clients, and that they feel this incredible pressure to respond immediately, or if they're not looking, that they feel like they're falling down on the job. And so that incredible amount of stress is, of course, people start self-medicating and those other things. And so I think the slide before, which talked about the increased anxiety and the increase in depression through COVID, is what I see as like a direct result of this kind of like eroded line between work and home.
And Betty,
I think we owe it. Yeah, I think we owe it to ourselves and to the people in our lives, other than our clients, to take care of ourselves. And one of the ways we can do that is by setting limits as to when you're going to be available. And even pre-COVID, years ago, I had a client who used to send me emails at 5 and 6 in the morning. And I did not read them until I got to the office, because I knew that if I read them, and he was a very stressful client to deal with, I knew that the stress level would kick in immediately. And I thought the only way I can manage this client is by not reading the emails until I get to the office, which was typically at 8 or 8:30. So it was still at a pretty reasonable hour. So it requires some self-discipline. And I think it's certainly much more of a problem since COVID, because no one figured that you had a life other than work. And but it's one of the ways that we can set limits, we can create boundaries, so that, again, clients have expectations. I'll be available during the workday, and maybe I'll be available on the weekend under certain circumstances, but generally not. There's plenty of hours during the week to conduct business. So I do think that we owe it to ourselves and to the people in our lives to set those boundaries.
That is great feedback. So let me jump ahead here, and this is simply a title slide that says, look at the materials that are attached. There is a fabulous array of things this panel has assembled, addressing the things Audrey's referring to, Betty has, Judge Beeman has. We won't go into those underlying materials because we want to really talk about what do we do, both as Betty was starting to address, what do we do to protect ourselves, as Audrey was also raising. I'm also very much of the mindset that we help ourselves manage stress and anxiety by helping our clients manage their stress and anxiety. And Judge Beeman and I discussed this at length, and that's where we'll go in a couple of minutes, is the issue of what do we do to reduce their stress and anxiety to help manage our own. So bear with me just a minute here. Let's go through these last couple of slides. The other thing and before we dive into that, when we had the roundtable conversations to set up this call today, what was really interesting was Betty, Audrey, Judge Beeman, everybody did our own little brainstorming session of what are some potential signs? What do we see? What do we actually see out there that may be indicative of anxiety issues, mental health issues, and the like? So I'm going to put up on the next screen and ask for everybody to provide perspective from the bench, from litigator's perspective, and the like. But also, when we were doing our brainstorming, I said, well, what are things you've seen? So here's what the group came up with. Judge Beeman, a lot of these are yours. So obviously you were talking about other people. You weren't talking about yourself, were you? The part about
I have certain Fifth Amendment rights here too, Mark. No, I mean, you can, a lot of these were my ideas, but I think Audrey had a number of ideas on a separate piece of paper. I heard something in the news the other day, and it just really clicked with me. It talked about rapidly increasing aberrant behavior. And so what they were talking about was a coyote that they ultimately shot over at the Presidio.
Yeah.
But, we don't see that in court very much. The overwhelming majority of lawyers want to do a good job and try to do a good job. What happens, I think, when you see these types of things in court, things aren't running efficiently. They're not being handled properly. One of the huge things for anxiety is not being properly prepared. And it's easy to say, oh yeah, you got to be properly prepared. Oh yeah, you need to be properly prepared. Well, what happens if, for example, you have no money in your business account, your partner didn't pay the PG&E bill, you're in the third or fourth day of a first-degree murder trial, and you can't take it anymore? Now, I'm not making this up. This is a story that really happened. I'm not going to go into any details. I don't want to be able to identify the people. But the lawyer in question, he's a criminal defense attorney. It was a court-appointed case. I mean, he feels like the entire world is coming on him. He's at his office at 6 o'clock at night. PG&E shuts off the power, and his secretary's concerned about him. She's trying to open the door, and he tells her, get away from the door. I've got a gun. If you keep this up, I'll shoot you. And then she's very concerned about him shooting himself. So she leaves. Okay, well, his legal career is over. Okay, it's done. But you have to ask yourself, at what point did this downward slide start? And what could have been done to help him to do it differently, to not wind up in this position? There are literally a gazillion ideas you can have. But I think the thing is we're talking about competency, and we're talking about avoiding and managing problematic behavior. One of the things that's easy to do is talk about all the problems in everybody else. I think if you slow down and look at yourself, and if you're in constant conflict or regular conflict with other lawyers, see what it is about you that you may be doing that is provoking that reaction. You have some control over your own emotions. Work with it. The other thing I'm jumping way ahead, Mark, and anytime you want me to shut up, just say so.
I had that electric button. I just have to find
Okay.
it.
All right. But I mean, the thing is, think about counseling. I think the thing that's so wonderful about these two women athletes recently is they're open and they're honest, and it takes guts and courage for them to do what they did. And today, even here, 2021, United States of America, the idea of people receiving mental health treatment, it still has a stigma associated with it. Lawyers don't want to impair their reputation. Oh yeah, he's the one that's got to go to a shrink. That's not it at all. It is smart to seek help when you're in that position. And you don't have to get to be, really bad. But as soon as you start having these anxieties and these sleepless nights and missing deadlines, well, seek some help, talk to some other lawyers. But the whole idea, and I guess my point is this, is getting mental health treatment is not bad. It's wonderful. Okay, I'll stop there.
Great, thank you, Judge Beeman. So Audrey, you heard from Judge Beeman, who has the benefit of both the judicial experience and of course this ADR work for a number of years. And your experience has been primarily litigation so far. In terms of both what you're seeing and what you think it reflects, love your observations here as well.
Yeah, I think Judge Beeman's point is a good one in terms of, nowadays, thankfully, people are more open to talking about mental health issues. my goodness, we're having a discussion on it right now. And that it's become more normalized where people can say, I have mental health issues, please can I have some help? So that's a very good point. In terms of competency, I had this one, potential client call me up one time and he thought he had a pretty good case, and I was doing kind of the intake and evaluation, and it involved like a breach of fiduciary duty in a minority shareholder situation. There were millions of dollars at stake. And as I was talking to him, I realized that he was actually represented by another attorney. And as I was kind of sussing that out, and he's like, oh yeah, you can go ahead and call that attorney. So then I called that attorney to get the procedural download and talk about some of the evidence. And that attorney then shared with me that he'd had some mental health lapses where he was, his medication was off. And so he was I don't want to say self-medicating, but he couldn't figure out the correct dosage of the medication. So he literally had like multiple weeks of just what he had said was like blackouts. And that what that happened is that when I was looking at the papers, it had manifested itself as he was non-responsive. So both to the client, where the client's like, hey, what's going on with my case? What are we doing? As well as with the court and opposing counsel, when they were asking him things, and it was just like radio silence, and he just fell off the, face of the earth. And the attorney said, yeah, my medication was so off that it's a big black hole for me. And he couldn't even remember what he might have said or did or not did or anything like that. So I think, certainly from a client's perspective or from an opposing counsel's perspective, if someone is just completely off the radar, maybe it's because they're super busy and they have a trial, but also maybe it's because they have some mental health issues. And I don't know if that's asking or cutting people slack, but it was an interesting way that it had come up. Another time I'd had kind of same thing. I was litigating this case. I'd had a really good relationship with the other side. We'd gotten through the discovery battles, but then all of a sudden he went radio silent, and it was just unlike him. And what happened? Well, it turned out that he'd had a cancer diagnosis, it was treatable and treatable, but it threw him for such a loop that he just completely, went dark. And because he was a solo, he didn't have anyone to either say, can you please step in and handle my cases or such. And so maybe the learning point on that one is, if you are a solo and you encounter something that just takes you out, whether it's a mental health lapse or it's just a health lapse, that you have someone who's going to be able to immediately step in an emergency situation, and who's your backup team, right? And be able to have someone at least call, like a secretary, to call and say, hey, so-and-so's out for the next 2 weeks, or something like that, to buy some time. But that's how those things have manifested, certainly.
That's great. So Betty, you are the lone person among the four of us with a true mental health professional background, although I think we all think we do mental health work when we're doing especially ADR work.
Yeah.
But Betty, you must have a lot of experience channeling that prior life.
No, I do. And I think I would take everyone back to the intake process, similar to what Audrey just described, in terms of she was lucky to find out what was going on with this client before, I assume, she chose not to represent him. Yeah. But I find that it's really important at that first contact with a client to try and determine if this is someone who you think you can work with. And I found that I could work with very challenging emotional clients because of my background, but that I could only represent so many of those people at any one time. So the timing of a new client may not have worked for me or for my staff, because I found that it really took its toll on staff. And what I'm sure you've all experienced is when your staff is stressed, that just adds to your stress. So protecting staff, your associates, your colleagues is another part of what we are able to do. So my view is that it's okay to decline representing someone because they're not a good fit for you in terms of how much time and energy they may demand. And I find, Mark, I'm not sure if this is the right time to talk about some of my thoughts around how to manage client stress. Do you want me to address those now?
Let me get rid of the slides. So I want to get to that. So just bear with me because I'd rather have it be our conversation than the slideshow. So
Can I just jump in on what Bette had said, though? I thought it was a really important point. So there was an article from the American Bar that just came out on May 1st of this year. And Bette, they were talking about surge capacity. And what they meant by surge capacity is how much capacity do you have on that extra, I guess, maybe buffer zone to deal with very stressful events or very stressful clients, and having some cognizance of how far can you stretch. And sometimes when we have all these other different factors that are coming at us, whether it's, kids who are remote learning or elderly parents who you're taking care of, whatever that is, whether personal or professional, or you're in your murder trial, that your surge capacity then gets less, and being able to kind of recognize that point and then seek help if you need it.
That's a really good point. I think it's really important. And I certainly found out that I could manage just so many challenging clients at one time. And if I got a call and it was going to be another one who would put me, kind of over the brink, it wasn't good for me and it wasn't good for them, because I wouldn't do my best work under those circumstances.
And this is great, great conversation. And maybe, I hope it's the right segue, because what I wanted to do is address just those issues, which is sometimes you have a client who you're just going to say no to. It is just too much. But many other times, I think we have the clients, and for whatever reason, we're gonna stick with them, and we're gonna help them get ready to go to court, get ready to go to a mediation, get ready to go to negotiation. And what I focus on, and I taught mediation advocacy for a couple of years at UC Davis's law school. It's like all the things we lawyers can do to help the clients de-stress. Now, they may get it right, they may still misbehave, but I think there's a tremendous amount we can do, and I know it's real because I have wonderful lawyers that I work with, and I know many of them do that pre-work. So the client is best able to deal with what is clearly stressful situations. Whether you're going before Judge Beeman, you don't know what he's going to rule. Or you're going to a mediation where you know that people on the other side have contrary interests and you don't know how your mediator is going to react, or you're going into a negotiation and your operating rule from back home, whoever you deal with, their expectations are what they are. The people on the other side have contrary expectations and the like. So I would love to hear from everybody in terms of what do you do to de-stress that client? What are some of the steps you have? I have my ideas, but I'm going to keep them till the end. In terms of preparing the client to reduce their stress and hopefully in turn reduce ours. So Judge Beeman, I know we've talked about this, you and I offline before. I know you've got your list of recommendations.
I do. I'm only going to talk about 3 or 4 things, but one of the things you have to, as an attorney, you need to take time with your client. Don't just treat them like a head of lettuce or a crop of clients. I mean, you really have to take time with your client. I'll give you 2 or 3 examples. Let's say a deposition. Preparing your client for a deposition. Take your time. Allocate as much time as it's going to take. Sometimes it's little as 2 hours. Sometimes it's 2 or 3 days. And while you're going through this, be respectful of your client. Be open and honest. Don't misrepresent the truth. Don't shade. What I see so many times in mediation and settlement conferences, plaintiffs' lawyers in particular, they want to keep the client. They want the client to do what they feel is in their best interest, but they're frequently inflating the worth of the case, how good this is, how strong the liability is, playing down comparative. they're not really being candid. They're not really being honest. And so the client winds up with these expectations that are unrealistic. And so they go to a mediation or a settlement conference, and for the first time, they're starting to hear all this negative stuff about the liabilities in their case. Well, that plaintiff's lawyer didn't sit down and go over the defendant's mediation brief with them, explaining to them why they're saying what they're saying, how that impacts the case. Frequently, they don't give them a record review or a defense IME. They don't even sit down and go over their own deposition with them. The clients, this is new to them. Lawyers live and breathe it, and they kind of like shove it off. But if you want your client to trust you, you have to spend time with the client and let them know that, show them the discovery you've done, why you did it, what it's accomplished. In many cases, it'll be appropriate to go with the client to the scene of an accident or go to a client's home. If you have a client that's in a wheelchair or something of that nature, you have to get to know the client's family, their support system, what they go through every single day. And you have to devote the time. If your caseload is too big, well, guess what? That's your fault. You got to whittle the thing down. I realize you have economic problems or issues, and you want to keep the new cases coming in the door, but there's a balance to be struck. Think back, what is that? How many cases do I have? How many is too many? What kind of help can I get? Who can I farm this out to? But insofar as the client and what you were trying to get me to talk about, Mark, the idea is avoid surprises, be open and honest with your client, and don't overinflate your case.
That's great. So practically, Audrey, how do you avoid those surprises? What are some things you might consider doing if you're going to either be taking him to court or take him to like an ADR session?
For the client, and we're talking about client, right?
Well, for both, obviously avoiding surprise for the clients, also avoiding surprise for you. So
yeah. I mean, it's really a repetition of what Judge Beeman had just said in terms of the preparation for the client and just making sure that you're preparing them ahead of time. Sometimes if they're going to be a very emotional or very difficult client, maybe even asking the mediator ahead of time to meet with them and have a private conversation, so that sometimes clients need to just get a lot of that emotion out and they just need to like vent it at someone. And during a mediation session, there's just not the time. So if we can handle it ahead of time, if you know it's going to be one of the, like if it's going to be an employment discrimination or sex harassment or something where there's like this like really personal dynamic and people feel like they've been wronged or they haven't been wronged or they've been accused of wronging someone, then they might need to do those sorts of things.
Great. Betty, where would you go with that?
I absolutely agree with what Judge Beeman talked about in terms of being honest with your client. And what I find is lawyers don't want to be the bearers of bad news. When they first took the case, it sounded like they had a great case, that things were really, really going to go well. And then as discovery proceeds, they find out, well, maybe the client really hasn't been honest. We know that happens, or that there are new facts that have been developed. So I think it's really important to share that perspective with the client, because as Judge Beeman said, surprises either at mediation or at trial are never a good thing. And so those conversations in preparation for whatever it is that's going to be going on is important. One other thing that I find is lawyers don't talk to their clients about what it's going to be like to be a witness.
Yeah.
And oftentimes these clients are not going to necessarily be good witnesses, either because they've got credibility issues or they appear evasive in their answers. And the lawyers are afraid to have that conversation with their clients. And as a mediator, there are times when I've taken a lawyer aside and said, are you aware of how your client may appear as a witness? And typically the lawyer is, but they haven't had that conversation. And so I'm glad to help them have a conversation by expressing my own concerns. Maybe it's based on reading a deposition transcript and then hearing kind of some contrary evidence, or just experience of the client couldn't answer my questions, and they're not going to be effective. And if your client's not going to be effective witness, assuming that person is plays an important role, then that's going to be a problem. The other thing, as was mentioned, is clients don't realize what it's going to feel like to go to trial. They do believe that what they see on TV is real, and they have no concept of the emotional toll, as well as the inefficiencies of a trial, the costs, the risks. And so those are really important considerations that a client needs to be aware of. And maybe one of the things to do is spend an afternoon in a trial, observing, see what that feels like. In my practice, most everything is a court trial, but in other practices where you've got jurors that are, going to be sitting and evaluating the credibility of witnesses, let the client see what that feels like. One of the things I've said to litigants as a mediator is, have you thought about how it might feel if your brother believes, if the court believes your brother and doesn't believe you? Because most of the trust and estate disputes are brother-sister or sibling disputes. And it never crossed the client's mind that the court would find that miserable person credible. And we don't know how the court's going to find them. So that kind of reality, I think, is really important. The other thing that's kind of one of my tools is to remember that I didn't create the problem that I'm trying to solve. I'll do my best to resolve it, but it's the client's problem, not mine. And my favorite story is one that I've told many times. When I was an associate at the firm and I came back from a deposition that did not go well for our client, and my supervisor asked how it responded, and I said, we had a really bad day. And the response of my supervisor was, no, we didn't have a bad day. Our client had a bad day. And I've told that story, and a number of my litigator colleagues have reminded me how often they've thought of that we didn't create the problem. We're going to try and solve it, but it's the client's problem. And I think that can really put things in perspective in a very important way.
That's very helpful. Audrey, you had something more you were going to add.
Yeah, I thought, Betty, that was a really important point. I think that that really hits home, certainly. I tend to talk in terms of we, meaning our client, and you just get really wrapped up into it being part of you. And so I think that's a really good point. We were talking about in terms of maybe having clients go off the rails and then everything gets maybe upset in surprises during a mediation. And maybe this isn't totally on topic, but I was thinking it's helpful from the litigator's perspective to have mediators or special masters or judges even being really proactive with both the case management schedule and talking about people in terms of, well, when are you going to do this discovery and when is it happening and when are just positive motions and all of those sorts of things, so that you can have the conversations with your clients, both in terms of what's coming down the road and how much it's going to cost. And then during maybe like a housekeeping meeting for an initial mediation session, also in terms of, well, what is it that you've shared for all of the other information that the other side needs? Because you assume that you get to the mediation and then all of that's been done, but sometimes it hasn't because people get really busy. And so so then the clients get like, shocked. So it's really helpful when we have mediators who are very proactive, who will set a time, a month ahead of time, the actual mediation date, if it's possible, to sit down with the, or have a Zoom or whatever with counsel and say, well, what are the things that are most important to your client that we're going to need to exchange? Like if it's in a, a wage and hour case, like the number of work weeks or whatever data or information or deposition stuff that needs to happen, has that been done and is this fully cooked for mediation? So then that way you can be able to have a full and fair discussion with your client and be honest and open, but you have to have the data and the discovery done in order to be able to have an honest assessment of the case and then have a talk with the client.
Well, and I think you're addressing something that I think we all encounter, which is we go to like a mediation session and one side has the information and they haven't shared it. And it's critical that the information be out there. I do a lot of wage and hour PAGA cases, among others, and the data drives the discussion. And sometimes people show up that day, or sometimes they deliver it the night before. And obviously there's inability to process it quickly, which goes back to, in my mind, some of the fundamentals of managing stress and anxiety is not just for your client, it's for the other client or the decision maker. And I use that term broadly to include organizations. Corporations are living human beings, they are. Insurance companies, living human beings, they are, because they're filled with individuals who come into every situation like we all do with our preconceived notions. And the more we prepare, not just our client, but more we prepare the other side, the more we're reducing their stress, the more hopefully we're getting them to a point of being able to assess things from a realistic standpoint. And so you're not hitting them over the head the day you all come together with, oh, we've got the surprising thing you haven't seen before. And you have to immediately reset your expectations in the moment. That's stress increasing, not stress reducing. Yet, and Judge Beeman and I, we've talked about this a lot, we run into situations where the lawyers choose not to share their briefs ahead of time. Well, think about what that does. If you choose not to share your brief, the other side only sees the other side's brief, and they like their brief because their brief says they're right and you're wrong, and they get more pumped up. Well, of course, their position is even better. If, to the contrary, we share briefs ahead of time, then the other side won't necessarily like reading your brief, but they'll at least start to adjust. And this is where I think timing is essential too. All the behavioral science data that I've been following, it's available for years and years, makes various points. We all like the good information, we discount the bad information. The longer we have sat on our preconceived notions, we're right and they're wrong, the harder it is to get people to reconsider. And obviously that reconsideration process sometimes takes time. So again, sharing that information up front is important. Sharing it early is upfront. It's not just for Judge Beeman and Betty and I to our convenience, but we don't just want to get it ourselves early. We want the other side to get it early so they can go through that processing. And as somebody who works with large corporations as well as small individuals and large insurance companies, there's sometimes multiple layers of people that have to get into the conversation. So the more we can prepare the other side, not just our client, prepare the other side, the more we de-stress the conversation and people hopefully show up with more realistic expectations. Judge, stole your points.
No, that's all right. I mean, it's a favorite subject of mine because I tell lawyers, I said, they write this, the world's best brief. There's never been a brief written in the history of the world better than this lawyer's brief, and he keeps it confidential. So I say to this attorney, I said, well, let me ask you this. How persuasive do you think your brief is with the other side? And they'll say, well, what do you mean? Well, you wrote this wonderful brief. I mean, what effect do you think it has on the other side? Well, you know they haven't seen it. I said, well, that's my point. It's a zero effectiveness. You don't need to convince me. I'm not giving you money. If you want money, you need it from the other side. And like Mark said, there's frequently 3 or 4 layers. I mean, lawyers think this is preposterous, but it's not. You get in the briefs 3 or 4 weeks early. Send them 2 copies. So, Larry Smith down the street could get one too. But, you have to get the information to them. As an attorney, as a litigant, you should be calling the other side after they've had the brief for a week or 2. Hey, did I leave something out? Is there something else you need? Ask your mediator, what holes do you see in my brief? What am I missing? What am I concluding wrong? I mean, the more you can front load it, the more you can get done before the day of the event. I mean, you're just that much further along. You're avoiding surprises. You might have the thing halfway resolved before you get there.
One thing I deal with a lot are accounting disputes, and I'm amazed that accounting information that typically should be shared is withheld. And of course, if you don't share information that should otherwise be available, people assume the worst. they assume you're hiding something. And so it creates this negative inference that may not exist, but for whatever reason, the information isn't being shared. And it's surprising. And I unfortunately sometimes get briefs just 1 or 2 days before the mediation, which is a little bit frustrating because it doesn't give me time to do as much pre-mediation work as I would like to. But I try and get that information. Yet sometimes they get it the morning of the mediation. They haven't had time to review it with their client, and it creates stress and unrealistic expectations, actually, because information that should have been shared hasn't been. And people have already got a mindset, oh, then it must be bad. That's why they're not sharing it, is because it must be bad for them. So I also would encourage people to share information well in advance, share your briefs in advance if that's possible, and definitely let the other side see your brief. And if you want to write something in confidence, you know, let the client write a letter that says all of the horrible things about their family that they want the mediator to know. Don't share that. That's not helpful.
Yeah.
But if you want the mediator to have all of the dirt, do so, because I think it can be cathartic. I think it's one of the reasons that mediation works, is people can really share their views in a pretty safe manner.
I had a mediator, a lawyer in front of me a few weeks ago. Of course, we'll go nameless, because we had this conversation about why does they have to have all that stuff in their brief, calling the other people names, and I won't repeat the names, but not good things. And that person said, well, it's because that's what my client wanted to see. My client wanted to see me
Right.
call them names. So
Right.
Betty, to your point, my rejoinder back is, first of all, you should have shared your briefs, but you should not share a brief with any invectives in it. If you feel that you think writing me a separate letter that calls them names is helpful for you and your client, that's good. You might want to stand up on the side though with your client and say, you know, the name calling stuff doesn't impress Judge Beeman. I sit as an arbitrator, pro tem judge. Doesn't impress me. I'm on the bench. Doesn't impress me in the mediation briefs. I'm sure it doesn't impress you, Betty. I'm sure it doesn't impress you, Audrey. But if the client, if the hook is, well, the client really wants to see me being mean to the other side, okay, separate letter, fine. When I taught at UC Davis, my mediation advocacy course, I told the students up front, if you use some of those words, the nasty words, you're going to get graded down. And it wasn't because I was being mean to them, but I said the most fundamental thing is if you're trying to get to a deal, whether it's a negotiation or a mediation, you have to get the people to move in your direction. For them to move in your direction, they have to hear what you have to say and absorb it. If you are calling them names, they don't hear. And again, what happens, the anxiety levels go up, not down. So we can do a lot of good by telling the lawyers that work, the people that are before us and clients, why we're sharing the information. That's just huge.
Mark, there was a question and from, I think it's a mediator, and it's curious whether you think the mediator should do that in advance. I think it's sharing information, requiring people to share information, or whether we mediators are then creating additional stress in advance of the hearing. Many cases go to mediation because one of the parties doesn't want to spend the time or the money to develop all of the evidence to know the outcome. I think that's a very good point, especially the early mediations.
I'll tell you, I've got a strong perspective only because I got all of my training initially from being in the Northern District California panel, where, as you all know, the presumption is you go mediate early. The exception is not to do it, and the court's trying to drive people to try and do this. And absolutely, Andrew, there are some cases where one side shows up unprepared, really unprepared to do something, and sometimes they both do. But there's almost always a couple of steps you can help them get through, and it may be, okay, we realize we haven't done this piece of work that'll be important, so call a timeout and come back. I think, unfortunately, I think Judge Beeman has heard me rant about this. I think the model that was created about 20, 30 years ago about what's called mediation is not really the right model. I think actually our family law mediators have a better idea. They recognize that sometimes you can go from start to finish, but most of the time you have to have a couple of stage conversations. It doesn't mean 3 days of mediations, but it might be 3 short conversations to get you to a better spot. And part of the, I think part of the anxiety reducing part with the conversations with the client up front is to let them understand, we think we're ready to get something done. The other side hopefully is ready to get something done. The more we share up front, we'll better understand their position, we'll better understand ours. But it is not a failure, mistake, a loss if we start that process and we go, okay, we need to call a timeout and do some more work and come back. And I think the mindset around this is the one shot we have is also not only anxiety producing for clients because they're desperate about, well, if we don't settle it, we fail. No, it might take 2 steps as opposed to 1. Not all the time. Hope most of my cases, like everybody's, I'm sure, resolved most of the time that first session, but move them away from that anxiety around there's only one chance, there's only one chance. But having said that too, I'll give you my last piece. During my general counsel days, I had an absolute rule with my legal staff, which is if I can't go to the mediation, you go. But you cannot go, or outside counsel cannot go unless they have not 1, not 2, but 3 substantive conversations with the other side ahead of time. Why 3? Well, the first one, when you pick up the phone and say, I'd just like to talk to you about the case, you surprise them. And more than once they go, oh my God, what are they trying to do? They're trying to trick us. And so the first conversation won't be as fruitful. Do 2, do 3, and it has to be real. It has to be, we want to share what we see. We want to hear what you have to see. And guess what? It reduces the anxiety of the lawyers. Most of them are not quite as evil or whatever adjective you want to apply to them. They're human beings too. They're probably a little stressed by the situation, to the prior comments that were made. They may have kind of overstated the value of the case when they first saw it too. We've all done that. So you start the conversation so you're all better informed. Then when you go into the mediation, the client is heard. If they follow Judge Beeman's advice, the client is heard from their own counsel. Well, there's some good news, there's some bad news, and it's not this horrible surprise being delivered in the moment. Those are all stress reducers and also improves everybody's chances.
Mark, can I follow up on one point
Please,
there?
please.
You talk about anxiety and things that produce stress. Well, something that produces stress with me is to get like 300 to 500 or 600 pages of exhibits 3 days before the mediation, and I'm doing a mediation or arbitration during those 3 days. I mean, it's just, it is not smart to do that to your mediator. It's not smart for your client's benefit. The other side, I mean, it's becoming more common to get these large bombs of exhibits, and the other side needs, a week or 2 or 3 to go through this stuff. It's just like derailing the entire process. What you also said about 2 sessions, what I've seen recently is people will book things for like 8 hours, and then either because they fail to properly prepare, which is normally what it is, at about the end of 4 hours, you're at loggerheads. It's just not going anywhere. Well, the idea is you still have 4 hours left. Let's break it off and come back when we're in a better position to be more efficient, more productive.
Yeah, and Audrey, you raised the other point about the prep work with the mediator, and I didn't want to lose track of that. All of us, I'm sure Bette, Judge Beeman and I, everybody I talked to, we want to hear from the lawyers what their concerns are about the case, including what their concerns are about the people dynamic on their side. We will guarantee you, whatever you tell us is confidential. If you're worried about that, but you always know your client better than we do. It's just reality. But if there's concerns, if there's some backstory that would be helpful for us to know, it's a little sensitive, but it's helpful for us to know so we can make a better connection with your client. We understand what's happening back home. Some of my best work has been attributable to great lawyers who call up and say, I want to tell you what's going on back home.
Yeah.
Here's the feuding business units. Here's
Right.
the problem with the insurance company. They think this case is this type of case and we think it's different. The more you can prep us, boy, we can help not only address the stress part of that, but come up with a plan. And that goes back to what all three of you have been saying, the value of starting the conversation with us early. We will always take a call to say, how can we help you better?
I think, Mark, I'm sorry to interrupt on
Yeah,
that.
no, I'm done.
I think experienced lawyers will do that and they'll make the phone call ahead of time. But I think there's a number of either junior attorneys or people who've just never done it before. And so it's really helpful if it comes from the neutral in terms of saying, hey, let's schedule a housekeeping, a month ahead of time. And then just to at least it starts the process, or at least people aren't realizing it's like a scary court process, but it's actually a dialogue. And I think that's helpful. I wanted to point out there's another question.
It's a really good question. It's a really important question.
Do you have suggestions for explaining to the client party the problems with their case without giving them the feeling that you are not on their side?
Great question. Betty, you want to start?
Yeah, here's my thought. That conversation needs to happen from the very beginning. That when you first get the case, you lay the groundwork to say, here's what I understand the facts and the law to be. As the case develops, my views may change. It's not because I'm not being an advocate for you, but because I have to be realistic about the strengths and weaknesses of your case. So from the very beginning, laying the groundwork for the client that things may change during the course of discovery and ultimately, hopefully, resolution. And to put it out front, to say to the client, I'm here to advocate for you the most effectively the way I can. But I think it's important for us to be realistic about what exists. And hopefully the client can accept that. And if you're in a mediation session, then certainly using the mediator to help you can be an effective way. But to start with the beginning of the representation, that things may change. That's not unusual. And so hopefully the client is prepared to know that with new facts, the view of the case may be different.
And that's huge, not just great advice. One of the exercises I did with my students was you do an initial assessment, and you have to write an initial assessment letter to the client. You cannot say you have a great case unless you condition it by saying, based upon the facts we've seen so far, you may have a great case. Right. But things may change. And obviously that also, it's self-protective, and it should be, in terms of there will come times, as happens to all of us, where something will go from good to bad or bad to worse. And if the client's first heard that, oh, things have gone from bad to worse, oh, you never warned me this might happen. That becomes a difficult client conversation.
Hey, Mark, in years gone by or time gone by, you've thrown me a zinger from a time or two. So I'd like to ask you a question. One of the things we're supposed to be talking about here is an attorney's well-being. And the question I want to ask everybody on the panel really is, what is it that judges could do to help support and foster attorneys' well-being?
Well, I'll give you, I do some pro tem work, and I'll channel more of my private arbitration work. And going back to Audrey's point, I think the best judges are the people that actively manage the dispute from the outset.
Absolutely.
And I'm old enough to be in the camp of the old days where there would come judges at the very beginning of the case would literally say, okay, let's all come back in chambers, everybody, no ex parte communication, of course, and take off the robe and sit there with us and say, what are we going to do about this case? And it was just great, because if you had good ideas, they made sense, the judge would listen, and things would move in the right direction. When I sit as an arbitrator, I try to mimic that process. I'm very proud of the fact that very few of my arbitrations ever go to hearing. I think if we're doing our job well as neutrals, like as judges, as well as mediators, you're helping them solve the problem. We're not, I know we get paid to be private arbitrators to go do a whole arbitration hearing, But if we help them solve the problem, that should be our first goal. And part of that is just sitting down exactly to this point, whether it's the pre-call with the mediators, whether it's the early sessions with the arbitrator, and just saying, what's the problem we're trying to solve and how do we get there? Not, who's going to get declared winner or loser? It's like, how do we solve the problems before us? And the most interesting work for me has been when you realize there's a whole range of things that you can do to solve the problem, especially in mediation, things you can talk about the courts can never order. That obviously gets to the ultimate point of getting people to a place that's acceptable for them, and getting people out of the litigation, pain that they otherwise are going to be in.
We're talking about like bad behavior, right? And opposing counsel bad behavior. And sometimes we see a lot of this in discovery fights. And there's like it's a letter writing campaign back and forth of, the junior attorneys or just the attorneys back and forth, like bashing on each other and just like creating all of this record so that they can attach it to their motions later on. And it's just like tons of just, name calling and things like that. And you kind of lose the actual thing, the thread of what we're actually fighting about in the production of documents or whatever. I think it's really helpful, Judge Beeman, you asked, what can the judges do or what I found is that if there's discovery referees, or if there's been, we've had some cases where there's been the judges who have been very inserting themselves, very active on this. And they say, I don't want to hear about X, Y, and Z about, so-and-so calling so-and-so or this little thing. And they're like, I want to hear about this. And this is the only thing I want to hear about. And so that's been really helpful, particularly for some of the attorneys where if you were attacked personally, that you feel like you have to spend 3 paragraphs talking about how the other side did all these terrible things. And when we hear from the judge that the judge doesn't want to hear about any of those things, or the referee, and they only want to hear about like this particular issue, and either calls a teleconference or a hearing or whatever, where they're telling people that, or an email sometimes we've gotten from the court, that's very helpful. So just focusing in the attorneys, particularly for the junior attorneys, I think that's helpful, where they feel like they have to fight over every little thing, right?
Well, and there's a growing body of case law. I'm sure you're all experiencing it. Federal court, state courts, where judges are expressing their impatience with people that are wasting court resources, making cases bigger than they need to be. I do a lot of trade secret IP cases where there's claims for attorney's fees and so-called exceptional cases, trade secret cases. But I'm just blown away by the number of courts that are just coming down really hard on parties because they are making things bigger than they need to be, having a lawsuit become bigger than it needs to be, go on longer than it needs to be. And under Supreme Court cases down to California appellate court cases the last few years, I think it's a reflection of course, we have a judiciary that's overworked, underpaid, overworked, and it's gotten worse after COVID. It's not going to get better quickly. And you have to be really judicious about your use of their time and resources. And it's part of the conversation that I have in my mediations, including one yesterday, where I said, you have to understand your case is important to you. The judge is not going to view the case as important to them, given what's left of this case, which wasn't that much. You need to all make this go away. This isn't just about you want to be right here. That's part of the reality. And I think part of the client conversation, just like saying the invective stuff doesn't help, is just to say, we have to be mindful of the fact that we're one of 500 matters on Judge Orrick's calendar. And if we engage in that personal attack stuff, nothing good comes from it. Betty, did you have more? We had one last question. I want to see if there's any more comment though.
One other thought that I think that judges could do to reduce stress has to do with scheduling, briefing schedules or hearings. And I was always appreciative of judges that were really mindful of how long things take to get done.
Yeah.
And that would allow enough time that, unless it's an emergency, doesn't create undue stress. Because meeting deadlines is one of the most stressful things that litigators have to do. And so judges that were really mindful of that in doing their scheduling, it was always really appreciated. One other, I know we only have a couple minutes left, and there's just one thing I wanted to share. In terms of, we talked about what are the tactics that we can use to kind of reduce the stress and manage difficult clients and difficult opposing counsel. And I particularly am not very tolerant at all of opposing counsel that used to yell, swear, threaten me, or clients who did that, because certainly I had clients that did that. And one of my favorite responses for that kind of behavior was to say, yelling at me is not going to solve your problem. And, you know, that sometimes would work. The other thing I found is that silence is a really powerful tool. And if you don't respond to that kind of behavior, that person can carry on, and finally they're going to wear themselves out. And then hopefully you can then have a productive conversation. But we don't have to tolerate that kind of behavior. And I see it, I've seen it in court, and I'm always frankly shocked that lawyers would think that yelling at a judge or losing their temper in front of a judge is an appropriate way to be an advocate. But not with a mediator, not with a litigator.
Judge Beeman?
I was going to say, I mean, Betty's point's well taken. I mean, judges bend over backwards to do their job properly and be fair to both sides. But when a lawyer stands up there and virtually tells the judge he's the village idiot about a half a dozen times, they react. I mean, you say, I don't want to hold it against him. I'm not going to hold it against him. It's not my fault he lost.
Audrey?
Yeah, we were talking about, again, how do you deal with bad behavior on the other side, that may be some competency issues. And what I'd like to do is really establish that personal relationship with opposing counsel so that you're not going to get into these discovery battles or whatever other type of battles. But if there is something that you're going to fight about, that you can be professional, that you're going to be citing the law, that you can be relying on the evidence, that it's not going to be these personal attacks. And the way that we get past those personal attacks is that we don't other the other side, right? It's that we actually, they're human beings. They have families just like us. And so sometimes I find people just, they just want to communicate via email, or they just want to communicate via letters. And it really makes a difference if you can like pick up the phone, or you can meet in person, although we're not doing that with COVID, or on Zoom, and actually establish a personal relationship with the other side where they realize that you're not just attacking them just to attack them as a person, but that you're really just talking about the particular strengths and weaknesses of your evidence. But if you can get through that part, I almost think of it as like the Wile E. Coyote, like the sheepdog cartoon, where they would clock in and then they would fight like crazy, or they, try to steal a sheep, and they do all these things, and then they clock out, and then like, hey, let's go grab a beer. Like those sorts of things where you have that personal relationship, and that it's so important not just to be civil, but actually to care, to find out about the real person on the other side. And then you can still fight and go to the mat and have a good time with that as well.
That was my version of that was what I mentioned earlier, my 3 conversation rule. Anticipate people will be guarded initially. And I'll quickly, 3 different GC positions. I parachute in and start looking at whatever I'm inheriting. There was this really interesting situation. There were a number of cases, thank God, not that many, but there were a number of cases in each situation where I look at it and go, why aren't we trying to just get this done? I mean, we can show them, our position is good, their position's weak, or whatever reason. Why aren't we trying to mediate right now? And with really good lawyers, I got the same response in all 3 positions as to this person or that firm. We can't do it because they're crazy or they're unreasonable. And I still would say, I still want to try. And whether we in direct conversations or we go to mediation, all of the descriptions about all the horrible behavior almost never played out. Once in a while it did, but the vast majority of the time people clean up their act in that situation. So reason, to Audrey's point, and I couldn't agree more, not letters, not emails. All those are like vehicles to justify your position. You pick up the phone and realize human beings are human beings most of the time. So we are at almost 1:30. We have a couple of questions, Ling, we didn't quite get to. Should we, I don't know, Fan, you were on, or Katie, can we take a couple of minutes more and run over? I'm assuming we can. If you go.
Yeah, I think there's just the one question in the chat
I
that's
think
left.
there's two,
Sure.
one from Judge Flyer.
Yeah, and I think Judge Fly, there's a great question, but I hope we kind of address that, is that, I guess my 2 cents always is don't assume bad behavior is like give up. Just sometimes you just keep talking to that person and they don't melt. They don't break down as much as you need to. And if it's really bad, you start documenting the really bad stuff and you go before the court, and you do the Michelle Obama thing. You take the high road, let them
Right.
take the low road.
Is there an obligation for reporting when you see like serious confidence issues?
There can be, certainly.
Yeah, I'm less familiar with that. So why don't we just really, because of time, there was one other, it's a great question by, can't read it. Oh,
Do you-
no,
It
okay.
says, do you attribute the breakdowns in civility that appear to be on the rise in litigation and in the practice of law to the lack of court funding and resources? Great question.
Folks, what do you think?
I think that that's not an
Yeah.
excuse. in my view.
No,
I agree fully, Betty. I think unfortunately, there's been some bad behavior modeled over the last couple of years.
Yeah, I mean, we've had funding issues for a long time, but we've had civility issues, I think, for longer. So I think that people are frustrated. I think that right now there's a lot of anger out there in the world. I think people are frustrated with COVID, their financial circumstances, their living arrangements, all of things that people are experiencing. I just think there's a lot of anger. But for us in this profession, I don't find it excusable that you take it out on opposing counsel or the court.
Yeah, and I just to confirm that it's not just it's unprofessional. It never advances the ball. I mean, that's what I tell clients. Judge Beeman?
no, I was just gonna, I mean, I agree. It's just so counterproductive. I can think of a few cases I had where one side was just, bizarre angry all the time. And the other side never responded, always took his time, very calmly and coolly explained his position, so that after, 4 or 5 days, the lawyer who likes to go off at the drop of a dime just appeared like the village idiot to everybody in the courtroom, including the jury.
Agreed. Well, folks, I think we could go for another hour or two on this topic. It's near and dear to, I think, all of our hearts, but we have used up our time. So I want to thank everyone. And are there any information they should have as to attachments or getting their CLE credits, anything like that?
They'll get them by Friday.
Okay.
Yep.
Do we get them too? Did we pass the competency test? Your jury's still out there.
Good. There's a lot of identifying, a lot of problem solving. It's good.
Well, I want to thank again the ADR Services and the Contrast Bar Association, and of course, Bette Epstein, the Honorable Paul Beeman, and Audrey Gee. This has really been fun to participate in. And Katie, thank you. We thought you had left. And
Sorry about that. Thank you, everybody.
yes,
Yeah,
thank you, everyone.